replacement of the attorney who was on record. And Mr. Kwenani appears for accused number 3, applicant 3. Mr. Gary van Wyk appears for applicant number 5. As you please.
Mr. Van Wyk.
As it pleases the court,
Yes, so do you confirm?
I confirm my appearance on behalf of applicant number 2, and I also confirm that I'm from Legal Aid South Africa, and I stand in for Tate Makameli to note the judgment. As it pleases.
Thank you. Right, Mr. Morori.
So what pleases Your Worship? Your Worship, I confirm my appearance on behalf of the first and fourth applicants in this matter.
Mr. Kwenani.
May it please the court, Your Worship. I confirm that I appear on behalf of applicant number 3. Court pleases.
Good day, Your Worship. As it pleases the court, I'm Mr. Gary Botha from Gary Botha Attorneys. I confirm my appearance on behalf of applicant number 5, and I confirm we're ready for judgment. Yes, please.
Thank you. Without much ado, I am ready with the judgment, and I will read it as follows. In the normal circumstances, I would prefer the accused, or rather the applicants, to be on their feet when I read out the judgment. Right, in the Magisterial District of Mangaung, held in Bloemfontein, under case number 28/113/2023, in the matter between the applicants, Sinoe Ishmael Matswara, Teboho James Dipulu, Mutenyane John Masukela, Tieo Franz Makhotsa, Nastasia Roshima Yanesi Janssen, versus the state which is a respondent in the matter. The bail application was firstly heard on the 11th day of May 2023, and today, the 29th May 2023, the court is ready and prepared to deliver the judgment. I had been called upon to adjudicate on the bail application under the said case number 28/113/2023. The applicants are Mr. Sinoe Ishmael Matswara, who is applicant number 1, Mr. Tieo Franz Makhotsa, applicant number 4. Both applicant number 1 and applicant number 4 are legally represented by Mr. Morori. Mr. Teboho James Dipolo, applicant number 2, who is legally represented by Mr. Van Wyk, who is before court to note a judgment on behalf of Mr. Makamedi. Mr. Motenyane John Masukela, applicant number 3, is legally represented by Mr. Kwenani, and Ms. Nastasia Roshima Yanis Janssen is applicant number 5, legally represented by Mr. Botha. State is represented by Mr. Matloko from the National Prosecuting Authority of the Republic of South Africa. According to the charge sheet, applicant number 1, Mr. Matswara, is facing 13 charges, namely 3 counts of fraud, 2 counts of violation of a body, 3 counts of the contravention of Section 3, Paragraph B, read with Sections 1, 2, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. Further charged with an offense of arson, contravention of Section 115, Paragraph B, read with Section 1 of the Correctional Services Act 111 of 1998, defeating the ends of justice, 2 counts of the contravention of Section 3, Paragraph A, read with Sections 1, 2, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004, and state alleges common purpose. Applicant number 2, Mr. Dipolo, is facing 10 charges, namely 3 counts of fraud, 2 counts of violation of a body, contravention of Section 3, Paragraph A, read with Sections 1, 2, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. Contravention of Section 3, Paragraph B of the Prevention and Combating of Corrupt Activities Act 12 of 2004, and further charged with an offense of arson. Contravention of Section 115, Paragraph B, read with Section 1 of the Correctional Services Act 111 of 1998, and defeating the ends of justice. Applicant number 3, Mr. Masukela, is facing 5 charges, namely 2 counts of fraud, arson, contravention of Section 115, Paragraph B, read with Section 1 of the Correctional Services Act 111 of 1998, and defeating the ends of justice. Applicant number 4 is facing 6 charges, namely 2 counts of contravention of Section 3, Paragraph A, read with Sections 1, 2, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004, further charged with an offense of arson, contravention of Section 115, Paragraph B, read with Section 1 of the Correctional Services Act 111 of 1998, defeating the ends of justice, contravention of Section 3, Paragraph B, read with Sections 1, 2, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. Applicant number 5 is facing 3 charges, namely arson, contravention of Section 115, Paragraph B, read with Section 1 of the Correctional Services Act 111 of 1998, and defeating the ends of justice. State is opposed to the release of all applicants on bail. All the parties, that is to say state and defense team, are at idem that bail application be dealt with in accordance with Schedule 5 in relation to all applicants, save as for applicant number 5, who her application will be approached by way of Schedule 1 offenses due to the late submissions by the public prosecutor that her application be dealt with as such. It is straight law that in Schedule 5 bail application, the onus rests on the applicant to show the court on the balance of probabilities that the interest of justice permits the applicant's release on bail. In non-scheduled offenses or offenses under Schedule 1, the burden of proof lies with the state to prove beyond a reasonable doubt that the interest of justice does not permit the applicant to be released on bail. In bail application, it is legally permissible for the parties to tender their evidence viva voce or by way of statements duly commissioned. All applicants in this bail application opted to use statements commissioned for them to be considered as candidates to be released on bail. Their statements were received by court and respectively marked as follows. Exhibit A1 in respect of applicant number 1, Mr. Matwara. Exhibit B1 in respect of applicant number 4, Mr. Makhotsa. Exhibit C1 in respect of applicant number 2, Mr. Dipolo. Exhibit D1 in respect of applicant number 3, Mr. Masukela. And Exhibit E1 in respect of Ms. Janssen. No further evidence was brought forth on the part of the applicants, and after closure of their application, state was afforded an opportunity to respond or react on the application by applicants. The public prosecutor led evidence of the investigating officer who testified at length, and after his testimony was subjected to a lengthy cross-examination by defense. Both the public prosecutor and investigating officer opposes the release of all applicants on bail. I looked into the contents of the statements in respect of each applicant and summarized them as follows. Applicant number 1 in Exhibit A1 says he intends to plead not guilty to all the charges preferred against him. He says he had been a resident for 12 years in Bloemfontein and has lived for 5 years at his current address. That he undertakes to attend his case religiously and has no desire to flee from police or to avoid the due and proper administration of justice. That currently does not have salary income, however survive out of odd jobs and gambling, and uses the monies he receives for his household necessities and provides for his life partner, 3 children at the age of 15 years, 13 years, and 7 years, respectively, as well as his father. Further, that he is the only emotional refuge of his paternal aunt. He says his further incarceration will negatively impact on his dependents, as he would not be able to generate income. He further says that he does not own immovable property, but do own a furniture and other utensils as estimated to not less than 60,000 rands. That he does not own property outside the Republic of South Africa and have no offshore accounts. He says he is a South African citizen and a holder of passport and has voluntarily gave in his passport and his cell phone with its passwords to the investigating officer as a means of cooperation with the police. That he does not have previous convictions nor pending cases against him. That he does not know the state witnesses and have no desire to contact them should they be known to him. He undertakes not to contact the investigating team nor to influence the investigations. He says his release on bail will not jeopardize his safety and or the sense of safety and security amongst the members of the public. That the criminal justice system will not be undermined by his release on bail. He is not a flight risk and will stand his trial. He further says that he wants to lodge his unemployment insurance fund claim with the Department of Labor, and that his further detention renders this intended claim impossible. He says he can afford to pay a bail of 3,000 rands and will abide by whatever conditions that may be set by this court. That is his evidence in the nutshell. Applicant number 2 in Exhibit C1 says he is a married man and do have 7 children, of which 3 are minors and attend school at Mangaung. That he contributes financially and emotionally towards the well-being of children. That his wife is unemployed and is suffering due to his continued incarceration. He further says that he had been residing in Bloemfontein for the past 13 years and he does have an alternative address at Van Stadensres, which is the place belonging to his family member. That he has a valid South African identity document and do not have a passport. That he does not have any family ties nor business interest outside the borders of the Republic of South Africa. He says he intends to plead not guilty to all the charges brought against him. He will stand his trial and attend all court appearances as he wishes to prove his innocence. He further says he handed himself over to the police. He says he will not interfere with any evidence or attempt to influence any witnesses should he be released on bail. Further, that he does not know the state witnesses and have no intention to interfere with the investigations. He further says he has no resentment to any person involved in this case and has no wish to harm anyone in this case. He undertakes not to contact or attempt to contact state witnesses. He further says there is no likelihood that he will endanger, rather, let me correct myself. He further says there is no likelihood that he will engage in the destruction of evidence or their hiding thereof, that his release on bail will not jeopardize or endanger trust of the community in the legal system. He asks the court to take into consideration that since his arrest, he had been struggling to communicate with his family as there are no public phones. Further, that they are not provided with sufficient blankets to keep themselves warm in the cells, and as a result, contracted a flu. That there is no medication relevant to his condition, and his further detention will negatively affect his current condition. He says he had been in custody since the 11th day of April 2023, and there is no indication when investigations will be finalized. He further says he does have a previous conviction of stock theft, offense committed in 2007, and that he does not have any pending case except the one before court. He says his family may assist him to pay a bail of up to 5,000 rands. Applicant number 3 in Exhibit D1 says he is residing at 1602 Staba Street, Kagisanong, Bloemfontein, at his own house. That he is employed at Group 4 Security as a custody officer and earn 15,000 rands per month. That he intends to plead not guilty in this matter. He says he is applying to be released on bail because he will not evade his trial and will attend court on all scheduled days. That he will not interfere with or contact state witnesses. He will not endanger the safety of the public. He is not posing any threat to anyone, and that he will not commit a Schedule 1 offense should he be released on bail. He further says he is suffering from uncontrollable diabetes, and that it will be better treated if he is granted bail. That he is a breadwinner and would like to go back and earn a living. Further, that he is not a threat to the factors listed in Schedule 6, subsection 4, paragraph A to paragraph E of the Criminal Procedure Act 51 of 1977. He says he can afford to pay a bail of 3,000 rands and will abide by the conditions that may be set by court. Applicant number 4 in Exhibit B1 says his permanent place of residence is 37721 Freedom Square, Bloemfontein. That he will plead not guilty to all the charges preferred against him. He undertakes to religiously attend his trial. He says he does not have a salary, however survive by doing odd jobs and also gambling. That he does provide for his dependents out of the odd jobs and gambling. He says he owns immovable property which he had been residing for a period of 17 years, and the value of that property is estimated at 150,000 rands. That he also owns furniture and other household utensils estimated to be not more than 15,000 rands. That he does not own any property outside the borders of the Republic of South Africa, nor does have offshore accounts. That he has 2 children that he must take care of, a 19 years and 12 years. That he is a breadwinner for his 78-year-old mother and his brother who are residing at Ruval. That he is a South African citizen with a passport, which he is willing to hand it over to the South African Police Services should a court so orders. He says he is arrested at his place of residence and cooperated with the police. He does not have previous convictions nor pending cases against him. He does not have a desire to flee from the police or to avoid the due and proper administration of justice. That he intends to attend his trial religiously. Further, that he does not know the state witnesses and have no desire to contact them if those witnesses come to his knowledge. He undertakes not to make contact with the investigation team regarding this case or influence the investigation. That his release on bail will not jeopardize his safety and or sense of safety and security amongst the members of public. Further, that the criminal justice system will not be undermined by his release on bail. He is not a flight risk and will stand his trial. He says his continued incarceration will make him not to be able to lodge his unemployment insurance funds claim and will also not be able to make follow-ups on his outstanding pension funds pay. That he will not be able to generate income out of odd jobs and gambling should he be further incarcerated. He says he can afford to pay a bail of 3,000 rands and will comply with whatever conditions that may be set by this court. That was his evidence in the nutshell. Lastly, applicant number 5 in Exhibit E1 says she is an unmarried 35 years female with 2 daughters that she has to take care of. That her residential address is number 9 Abdurrahman Street, Ashbury, Heidedal, Bloemfontein, and says and stays with her parents, sister's children, and her own children. That she does not have a passport and she does not have a business outside the Republic of South Africa. She does not have family members outside the borders of the Republic of South Africa. She is unemployed. She is dismissed at Group 4 security company. She is suffering from migraine and head pains and buys medication over counter from the pharmacy. That there is no warrant of arrest issued against her, and she neither have previous convictions nor pending cases against her. She intends to plead not guilty to the charges against her. She says there is no prima facie case against her. She does not know the state witnesses. She needs to be released on bail so that she can be able to look for a job, to be able to provide for her 2 daughters. In as far as the provisions of Section 60, subsection 4, paragraph A to E of the Criminal Procedure Act 51 of 1977 is concerned, she says she will not endanger the safety of the public or any public person, including her own safety. That she will not commit offenses while out on bail. She will not attempt to evade her trial and will come to court on all dates directed by court. She will not interfere with the state witnesses or attempt to conceal or destroy evidence. That her release on bail will not jeopardize the objectives or proper functioning of the criminal justice system, including bail system. Further, that her release on bail will not disturb the public order or undermine the public peace or security. She says she can afford to pay a bail of 5,000 rands and she will report herself to the Heidedal police station every Friday between 6 a.m. and 6 p.m. That was her evidence in the nutshell. I also felt necessary to summarize the evidence of the investigating officer as follows. Lieutenant Colonel Flyman says this case before court relates to the escape of Thabo Bester from prison. He told the court that applicant number 1, Mr. Matswara, has a motor vehicle registered in his name. However, the address registered in relation to that motor vehicle is not the same address he provided to the police. The address in relation to the registration of a motor vehicle is his sister's address, Vide, 5910 Mushweshwe Street, Rocklands, Bloemfontein. He further told the court that applicant number 1 is dismissed from his employment and there are some payouts made from his pension funds. He told the court that applicant number 1 have traveled to Lesotho in October and November 2022. He says applicant number 1's passport shows that he had been in Lesotho 8 times, since his passport is having 16 stamps showing exit and entrance. He says he did establish that applicant number 1's rapid traveling to Lesotho is because he does have relatives in Lesotho, but he does not know as to how he relates to those people in Lesotho. That applicant number 1 has a passport, however, it is currently in his possession. Further, that applicant number 1 does not have previous conviction or pending cases against him. Colonel Flyman says applicant number 1 was a supervisor at his employment and was in charge of Group 4 security, EST members, whose responsibilities, amongst other things, was to take care of the prisoners and to prevent escape. He told the court that applicant number 1 is the one who took a corpse into the prison. That on the 27th of April 2022, accused number 2, Mr. Sekeleni, hired a motor vehicle, a van, from OR Tambo and drove it to Bloemfontein, whereby on the 29th day of April 2022, the same car was driven by applicant number 1, carrying a corpse that was taken to G4 prison. He further told the court that as per his investigations, he came to know that there was an unknown male person who happened to collapse at a taxi rank, who then was taken to the National Hospital and died whilst attempt was made to resuscitate him. That the same corpse of unknown man was then claimed by accused number 4 in this case, Nandi Pamakudumana, who said the said corpse is of Zanda Moyo's brother, and she is assisting Zanda Moyo to bury his brother. That the said corpse was then taken to Tusano Mortuary and ultimately taken to phase 2 location, where there was a funeral arranged, and that is where applicant number 1 got and took the corpse. He further told the court that the corpse was never buried because there was an exhumation that was made, and only to find that in the coffin was 3 10 kgs of melamel, and there was no human body or remains. He further said that the corpse was put into or beneath the TV stand that was loaded on the van, and applicant number 1 drove it to Group 4 prison. He says that in Group 4 prison, there is a place or site called Salipat, and its entrance is controlled, in that a gate pass is required before one can gain entry. That applicant number 1 had no gate pass on the day in question, and applicant number 3, Mr. Masukela, was designated to operate at that entrance gate. He also said that before getting to Salipat, there is another door controlled by the people in the control room, and those people on that day was Irene and Rachel, the 2 persons who are not before court. That applicant number 3 wanted to get a gate pass for applicant number 1, but one Mr. Danti, a supervisor on the Salipat, refused and ordered that applicant number 1 should not be allowed entry without a gate pass. He told the court that Mr. Danti then received a call to attend a particular emergency inside, an emergency that was not there, as that was to create an opportunity for applicant number 1 to gain entry into the Salipat. And indeed, applicant number 1 drove in and was assisted by applicant number 3 to offload the corpse. He further said that applicant number 2 took a corpse and placed it inside a dustbin trolley, and thereby pretended to be cleaning the prison yard. Applicant number 2 then took a corpse to a Broadway, which are the single cells for prisoners. He said Broadway entrance is also controlled from CCR. However, applicant number 2 was a technician and caused a disconnection of the system, and then took a corpse to a dark room and left it there. He further told the court that applicant number 2 was supposed to have knocked off from his duties on the second day, May 2022, but pretended to clock out and instead remained behind. That it appears it was at that time when they were planning as to how the corpse should be taken to cell number 35. He further said that applicant number 1 was off duty on the night of the second day of May 2022. However, requested to be on duty for Mr. Bartman, who was supposed to be on duty on that day. That there is a block area called Walls, whereby personnel working in that block said applicant number 1 went to the cell of 4 inmates and spoke to them. That the supervisor is required to register his visit to the cells for inspection, but applicant number 1 as a supervisor did not register his visit. He said in the middle of the night on the second day of May 2023, it was reported that there was a smoke in cell 35, and ultimately cell 35 was on fire. He further said cell 35 is a cell that was occupied by Thabo Bester, and as fire got extinguished, it was discovered that there is a corpse burned, and it was believed to be one of Thabo Bester, or it was believed to be Thabo Bester, that he committed a suicide. He said Thabo Bester is accused number 5 in this case. That Thabo Bester was given a Group 4 uniform to disguise himself when getting out of prison, and was with applicant number 2 at that time. He further told the court that applicant number 4 and number 5 were working in CCR room, and that is where they are operating cameras. He says to the court that both applicant number 4 and number 5 were on duty on the second day of May 2022 and were once opening doors, including the one that Thabo Bester used when he got out of prison. He says all the applicants facilitated the escape of Thabo Bester because of the money. That applicant number 1 promised applicant number 2 a 2.5 million rand if he could help in Thabo Bester's escape. The applicant number 1 paid applicant number 2 a 30,000 rands, which was paid into applicant number 2's wife bank account, and this was verified through the bank statement of applicant number 1. Further, that a further 10,000 rands was paid to applicant number 2 through his bank account. That further payments were made to the total of 150,000 rands. He further told the court that his investigations revealed that Thabo Bester was the one who was transferring monies to applicant number 1, and he was using different names. He told the court that applicant number 4 was also paid 10,000 rands and thereafter another 4,000 rands. And there is a proof in the form of a bank statement of applicant number 4, and the money was paid by applicant number 1. He, however, told the court that there is no proof that applicant number 3 and applicant number 5, they also received monies. He further told the court that on the 21st day of April 2023, DNA results were formally obtained in relation to the corpse found in Thabo Bester's cell and got buried by the loved ones. He told the court that the family did not know the whereabouts of their loved ones since April 2022 until the 21st of April 2023. That the family members, community members, including Celtics Football Club supporters, were angry. Mother and grandmother were heartbroken when they heard what happened to the corpse of their loved one. He further said this news were heartbreaking to the members of community and rose high emotions that may lead to community unrest should the applicants be released on bail. That the community is against the release of the applicants on bail, and this was demonstrated at the funeral of the deceased, as the Celtics Football Club supporters were saying they don't see why and how the applicant can be released on bail. He further said Bloemfontein Celtics supporters were picketing outside court during applicants' bail application, showing that they are against the release of applicants on bail. He told the court that he is opposed to the release of applicants on bail, in that their release on bail will spark community unrest and community members will take law into their own hands. Further, that the judicial system will be said to be useless, that even the manner in which the offenses were committed shocked the nation, hence there is this media coverage for this case. Further, that the state witnesses' lives will be in danger as the applicants are believed to know them since they were co-workers. That it will be in the interest of justice, particularly for applicant number 2, to be kept in custody as he is also fears for his life. That was the investigating officer's evidence in the nutshell. He was then subjected to cross-examination at length by all applicants' attorneys and answered all questions posed to him. He considered where he made mistakes, and when asked some questions where he does not have the answers, he responded promptly by saying he does not know. He gave answers favorable to the applicants when was necessary. I cannot fault him. He was honest and did not find I did not find any malice on his part. He, however, remained adamant that the applicants should not be granted bail. After cross-examination, the public prosecutor was offered an opportunity to re-examine him to clarify some issues. After all evidence placed before me, all the parties were afforded to address the court before this judgment. Mr. Murori argued on behalf of applicant number 1 and applicant number 4 that the interest of justice permits their release on bail. He argues with reference to State versus Uni 1073, Volume 1, SA 842, Cape Town decision, that in that case it was held that the view of investigating officer in bail proceedings is not only view that must be considered, nor is the most important one that should weigh with a court as to whether or not should be granted bail. Let me read the same sentence again. He argues with reference to State versus Uni 1073, Volume 1, SA 842, Cape Town Division, that in that case it was held that the view of investigating officer in bail proceedings is not the only view that must be considered, nor is the most important one that should weigh with I want to believe with the interest of justice, and as to whether no bail should be granted. He further draws court's attention to the provisions of section 35 subsection 1 paragraph F and subsection 3 paragraph H of the Constitution of the Republic of South Africa Act 106 of 1996, of which to be read in conjunction with the provisions of section 60 subsection 4 of the Criminal Procedure Act 51 of 1977. He further advanced his argument by referring this court to the litany of case law. I must mention that the argument he advanced to court in respect of applicant number 1 is similar in nature to one he advanced in respect of applicant number 4. The address as to arguments advanced by Mr. Makamedi on behalf of applicant number 2, Mr. Kwenani on behalf of applicant number 3, and Mr. Buotha on behalf of applicant number 5 found to be repeating and hammering on evidence in court as per their statements. They also make reference to the provisions of section 35 subsection 1 paragraph F of the Constitution, section 60 subsection 4, and refers court to case law. Mr. Buotha in particular argues, and he is emphatic, that there is no prima facie case against applicant number 5. Else, state has no strong case against her. They all argue that the applicants have discharged their onus on the balance of probabilities that the interest of justice permits their release on bail. On the other side, the public prosecutor argues that applicant number 1, number 2, number 3, and number 4 all did not discharge the onus on the balance of probabilities that the interest of justice permits their release on bail. He argues that all the applicants' legal representatives refers to the rights of the applicants enshrined in the Constitution, but do not mention the limitation clause as per section 36 of the Constitution. He argues that the applicants' attorneys did not address all factors as mentioned in section 60, subsection 5 to subsection 8, capital letter A of Act 51 of 1977. He argues that as per the testimony of the investigating officer, some grounds have been established under section 60 subsection 4, paragraph B, C, and E. In this way, the interest of justice does not permit the applicants to be released on bail. He argues further that the evidence by the applicants is by statements, and a lesser weight ought to be attached by court when weighing evidence in total. Though he submitted, as for applicant number 5, that her release on bail to be approached as per Schedule 1 offense, he submits that state opposes her release on bail. He further submits that state case is strong against all the applicants. At this point, I must now come in to determine and reach a just decision as to whether the interest of justice permits the release of the applicants on bail or not. I must mention that a bail inquiry is a judicial process that has to be conducted impartially, judicially, and in accordance with the relevant statutory and constitutional prescripts. The provisions of Section 2 of the Constitution provides that this Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligation imposed by it must be fulfilled. The provisions of Section 12, subsection 1 of the Constitution provides that everyone has the right to freedom and security of the person, which includes the right, paragraph A, not to be deprived of freedom arbitrarily or without justa causa. And paragraph B, not to be detained without trial. It is appropriate to immediately refer to Section 35, subsection 1, paragraph F of the Constitution, which provides that everyone who is arrested for allegedly committing an offense has the right to be released from detention if the interest of justice permits, subject to reasonable conditions. Section 35, subsection 3, paragraph H, provides that every accused person has a right to a fair trial. Every accused person has a right to a fair trial, which includes the right to be presumed innocent, to remain silent, and not to testify during proceedings. It will also be prudent for me to also refer to the provisions of Section 36, subsection 1 at this juncture of the Constitution of the Republic of South Africa, which provides that the rights in the Bill of Rights may be limited only in terms of law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account all relevant factors, including the nature of the right, the importance of the purpose of the limitation, the nature and extent of the limitation, the relation between the limitation and its purpose, and less restrictive means to achieve the purpose. The bail application proceedings are governed by the provisions of Section 60 of the Criminal Procedure Act 51 of 1977. Section 60, subsection 1, paragraph A, provides that an accused who is in custody in respect of an offense shall, subject to the provisions of Section 50, subsection 6, be entitled to be released on bail at any stage preceding his or her conviction in respect of such offense, if the court is satisfied that the interest of justice so permits. The bail application in relation to applicant number 1, number 2, number 3, and number 4 falls under Schedule 5, and Section 60, subsection 11, paragraph B, provides that in Schedule 5, but not in Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that the interest of justice permits his or her release. It is right law that the onus rests on applicants in Schedule 5 bail application to prove to court on the balance of probabilities that the interest of justice permits their release on bail. Thank you. The applicants did not testify viva voce, or no evidence was viva voce led on their behalf, but used statements under oath in support of their application. On the other side, state led viva voce evidence in response to the applicant's applications. The public prosecutor correctly argues that not much weight must be attached to the evidence by statements. This is so for the evidence of the applicants were never tested by way of cross-examination. In State versus Brenkis, 2003, volume 2, SACR, page 575, the Supreme Court of Appeal and in State versus Matebula, 2010, Volume 1, South African Criminal Law Report, page 55, Supreme Court of Appeal, it was stated that evidence on affidavit is less persuasive than oral evidence. It is argued by all the legal representatives of the applicants that the court should take into account that they are presumed innocent until guilty proven. This court do have the respect of the applicant's rights as enshrined in the Constitution. However, I do have a different view that the right of presumption of innocence, as postulated in Section 35, subsection 3, paragraph H of the Constitution, is not intended to be a bail right, but a trial right. The same view was echoed in State versus Dlamini, 1999, Volume 2, South African Criminal Law Report, on page 51, Constitutional Court. Further citation may be looked into 1999, Volume 4, SA, page 623, and 1999, Volume 7, BCLR, page 771. It was further said on the same decision that the duty of the court in a bail application is to prima facie determine the relative strength of the state case against the bail applicant, as opposed to making a provisional finding of guilt or innocence of such an applicant. I now move to deal with the pertinent provisions of Section 60, subsection 4, paragraph A to E of the Criminal Procedure Act 51 of 1977. I believe both state and defense have quoted this section over and over, and I do not intend to quote it verbatim or seriatim. I will refer to parts that I deem necessary. I must state that on evidence presented before me, I found that grounds mentioned in Section 60, subsection 4, paragraph A and paragraph D are not established. However, I find paragraph B, paragraph C, and paragraph E having been established. Subsection 4, paragraph B provides that the interest of justice does not permit the release from detention of an accused where there is the likelihood that the accused, if he or she were released on bail, will attempt to evade his trial or her trial. Subsection 6 provides that in considering whether the ground in subsection 4, paragraph B has been established, the court may, where applicable, take into account the following factors, namely, amongst others, paragraph F, the nature and gravity of the charge on which the accused is to be tried. Paragraph G, the strength of the case against the accused and incentive that he or she may, in consequence, have to attempt to evade his or her trial. Paragraph H, the nature and gravity of the punishment which is likely to be imposed should the accused be convicted of the charges against him or her. In this regard, I will argue that all the applicants did not deal effectively with the aforementioned factors and as a result thereof found to be existing and dictates against the application. Further, subsection 4, paragraph C provides that the interest of justice does not permit the release from detention of an accused where there is the likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses to conceal or destroy evidence. Subsection 7 provides that in considering whether the ground in subsection 4C has been established, the court may, where applicable, take into account the following factors. At paragraph A, the fact that the accused is familiar with the identity of witnesses and with the evidence which they may bring against him or her. At paragraph D, the relationship of the accused with the various witnesses and the extent to which they could be influenced or intimidated. On this point, I bravely reject the evidence by the applicants when they say they do not know the state witnesses and potential state witnesses purported to be co-employees with the applicants. That argument will defy logic and is questionable. Honestere vivere et sum seque tribuere. Yeah, one must live honest and give what is due to each. I do find the aforementioned ground to have been established. Subsection 4, paragraph E, provides that the interest of justice does not permit the release from detention of an accused where in exceptional circumstances there is the likelihood that the release of the accused will disturb the public order or undermine the public peace or security. Subsection 8, capital letter A, provides that in considering whether the ground in subsection 4E has been established, the court may, where applicable, take into account the following factors. Videlicet. At paragraph A, whether the nature of the offense or the circumstances under which the offense was committed is likely to induce a sense of shock or outrage in the community where the offense was committed. At paragraph B, whether the shock or outrage of the community might lead to public disorder if the accused is released. At paragraph C, whether the safety of the accused might be jeopardized by his or her release. Paragraph D, whether the sense of peace and security among members of the public will be undermined or jeopardized by the release of the accused. Paragraph E, whether the release of the accused will undermine or jeopardize the public confidence in the criminal justice system. I further find that the above ground is established on evidence before me. The applicants, I must mention once more, they did not deal with the factors as aforementioned effectively. I will also argue that the nature of the case itself, it is of its own unusual and thus attracts the application of subsection 4, paragraph E. I have considered the provisions of section 60, subsection 9, and I have weighed the personal circumstances of the applicants as against the interest of justice. On evidence presented before me, I am convinced that there is a prima facie case against applicant number 1, number 2, number 3, and number 4. Court is also concerned about these allegations, as it appears that the offense was committed in cahoots with the people whom a trust was bestowed, that the offense was committed at a place expected to be secured and a safe place. It is hard, if not possible, to find the personal circumstances of the applicants outweighing the interest of justice in this case. I therefore find that the interest of justice do not permit the release of the applicants number 1, number 2, and number 3 and number 4 on bail, and as such, bail is denied. As for accused number 8, I intend not to waste time as to her position. State case against accused number 8 is porous, and personal circumstances before me in relation to accused number 8 serve as an open sesame for her to be released on bail. State did not prove beyond reasonable doubt that the interest of justice does not permit her release on bail. Consequently, she is admitted to a bail.
Please,
Please, the court.
Someone pleases your worship.
Thank you. State, Mr. Makoko, what must happen with the case?
Can we hear from Mr. Botha in terms of the affordability of applicant number 5? The court has now found that she is entitled to bail. We should now make an inquiry in terms of the amount of bail that she can.
As it please the court, your worship.
I think I do have it as evidence. I do have it as he argued before me.
5,000.
As he argued before me, he said the court may set a bail of 5,000 rand or court
To
may go to
10,000.
10,000. Thank you.
And this indeed so, your worship.
Thank you.
I will then go to the extreme and ask the court to set the amount at 10,000 rands, which is what she says she can afford.
No objection, your worship.
That's it.
Thank you.
If that is the case, Your Worship, state will then request that the main matter against the accused, be remanded to the same date and for the same reason that the court has already remanded the matter of the other accused, that being the 20th of June 2023, for further police investigations. Accused 1, 2, 3, 4, and 5, and 4. Applicant 1, 2, 3, 4 remain in custody, and applicant number 5 remain in custody on proviso that she pays whatever amount the court will order against it, as the prison court.
Thank you. Dates agreed.
That is in order, your worship. Yes, we had previously agreed to the date of 20th of June, I believe. That's the court
Thank you.
pleases.
As it pleases the court, the date is correct, the 20th of June, as it pleases.
Thank you.
court pleases, it is suitable indeed, Your Worship.
Thank you. Yes, your case is remanded until the 20th day of June 2023. Same court number 20A for further investigations as well as for your co-accused. Accused number 1, accused number 3, accused number 6, accused number 7. All of you will remain in custody until then. Bail is denied. Accused number 8, you are in custody. Bail is set at an amount of 10,000 rands on the following conditions: that you are ordered, upon payment of bail money, to report yourself on Fridays to Heidedal Police Station at 6 in the morning and 6 in the afternoon. You are further ordered not to directly or indirectly have a contact with the state witnesses. You are ordered not to leave Bloemfontein without informing the investigating officers of this case. You are warned to appear before this court at 8:30 in the morning and to remain in attendance should bail be paid. Failure to appear a warrant of arrest will be issued, your bail will be provisionally cancelled, bail money be provisionally forfeited to the state. Understood? Thank you.
Yes, please the court, Your Worship.
I believe we can adjourn for now. I'm not sure how the roll looks like, but for the purpose of this matter, we may adjourn.
Okay, court adjourns.
All rise.